The most crucial information on the immigration rights of the Borneo states. The existence of Malaysia depend on the special law of immigration for the Borneo states of Sabah and Sarawak under Article 5 of Malaysia Agreement 1963. It has been expressed that the government of the Federation of Malaya will take such steps as may be appropriate and available to them to secure the enactment before Malaysia Day by the Parliament of the Federation of Malaya of an act in the form set out in Annex E to this agreement for the purpose of extending and adapting the Immigration Ordinance, 1959, of the Federation of Malaya to Malaysia and of making additional provision with respect to entry into the states of Sabah and Sarawak, and the other provisions of this agreement shall be conditional upon the enactment of the said Act. Article 5 of Malaysia Agreement 1963 required that the Federation of Malaya to pass Immigration Bill as set out in Annex E of Malaysia Agreement 1963. This bill has been passed and enacted as Immigration Act 1959/63. Under this Chapter 2, special provisions, of this Act, it has been expressed under Section 64(1), that, without prejudice to the general operation of Parts 1 to V, in East Malaysia as in Peninsular Malaysia, as a general law for Malaysia as a whole, those parts shall also have effect, subject to and in accordance with this chapter, as a special law for each of the East Malaysian states as if for any reference to Malaysia, except in a reference to a government in Malaysia, there were substituted a reference to the East Malaysian state. Clearly, it has been expressed here, that, those parts shall also have effect, subject to and in accordance with this chapter, as a special law for each of the East Malaysian states. This means, immigration rights of Sabah and Sarawak as a special law. However, the most crucial information that a lot of people has overlooked is written in Article 5 of Malaysia Agreement 1963. Here, it has been written that, the other provisions of this agreement shall be conditional upon the enactment of the said Act. This means, all the terms that has been agreed in Malaysia Agreement 1963, is depending on the passing and enforcement of immigration rights of Sabah and Sarawak. If the immigration rights of Sabah and Sarawak is not passed by the Federation of Malaya, the whole terms that has been agreed in Malaysia Agreement 1963 will collapse and Malaysia will not come into existence. Therefore, the mere existence of Malaysia depend on the enforcement of the immigration rights of Sabah and Sarawak. If the immigration rights of Sabah and Sarawak is being questioned and being amended recklessly, all other terms agreed in Malaysia Agreement 1963 will collapse. If this happen, Sabah and Sarawak will not agree anymore with the formation of Malaysia and federal constitution. Automatically, as agreed under Annex A of IGC report, once the immigration rights of Sabah and Sarawak has been breached, the government of Sabah and Sarawak can appoint their own foreign affairs minister and send the delegate to the United Nations for the dissolution of Malaysia. This is the most crucial information on the immigration rights of the Borneo states. The existence of Malaysia depend on it.